Welcome, everyone, and thank you for joining us today. We're excited to kick off our three-part webinar series exploring hospital and physician dynamics, a primer on medical staff adverse actions. My name is Todd Brower. I'm a partner with Frier Levitt, and I'm pleased to be joined by my colleague, Alex Keoskey, today. A few housekeeping matters before we begin. Which the first one is being able to advance my screen. Here we go. As attorneys, of course, we have to put in our usual disclaimer. The materials, information provided in this presentation are for informational purposes only and not for purpose of providing legal advice. And the information contained is basically an overview and should not be construed as legal advice or exhaustive coverage of the topics. A little bit about Frier and Levitt. We are a national law firm focused on primarily healthcare and life sciences. We're a little over 50 attorneys. Our life sciences attorneys present pharmacies and all other businesses involved in that end of the healthcare realm. Their attorneys represent pharmacies, assist with regulatory, transaction, litigation matters. And the other side of the firm is our healthcare side, where we represent providers, individual physicians, medical staffs, hospitals, with regard to transactional, regulatory, and compliance types of issues. Again, my name's Todd Brower. I am a healthcare attorney. I've been counseling hospitals, medical staffs, physicians for a number of years with regard to medical staff matters, with regard to mergers and acquisitions, compliance, regulatory matters. Previously, I was the Senior Vice President, General Counsel for St. Joseph's Health. And prior to that, spent over 31 years as a healthcare attorney in private practice. As I mentioned before, I'm being joined by my colleague, Alex Keoskey. Together, we will be covering critical topics such as disciplinary actions, the importance of civility, and the impact of adverse actions on professional records. I obviously will be coming from the perspective of the hospital and medical staff, and you'll get the insight of Alex from the physician's standpoint. Today's presentation is going to be an in-depth discussion on the types of adverse actions brought by hospital medical staffs and the reasons behind them. Alex, could you please introduce yourself at this time?
Certainly. Thank you, Todd. Pleasure to work with you today and on this entire webinar series. I'm Alex Keoskey. I've been in practice a while. I started as a Deputy Attorney General for the New Jersey Division of Law. I used to prosecute for the healthcare licensing boards for 6 years. Back in the 90s. I spent 20 years as a compliance officer for the largest federally qualified health center in New Jersey, up in Hudson County, the North Hudson Community Action Corporation Health Center. Also certified as a healthcare compliance officer, certified as a civil trial attorney. And I also teach for a group on the faculty of a program known as PBI Education in joint providership with the UC Irvine School of Medicine in California. And I teach professional ethics for that entity, and happy to that you're all joining us today, and happy to be working with Todd, which I do every day on matters of this type. So Todd, take it away.
Thanks, Alex. Few additional housekeeping matters. Just so you know, this is being recorded. And also during the webinar, if you have any questions, you can send them through the Q&A tab on your screen. The questions will be private. Only Alex and I will be seeing them. We will try to answer as many questions as we can, but if we don't get to them all, or you think of some questions later, you have our contact information there. Please feel free to reach out to us, and we'll be happy to address them for you. I also want to announce that part 2 of the series is scheduled for June 25th, and it's going to cover civility and communication, managing disruptive physicians, and addressing harassment complaints. So at this time, we will get started. Well, of course, now it's frozen. Here we go. Okay. The focus today is going to be on quality of care issues. As you know, the medical staff, generally through the Medical Executive Committee and other committees, most notably your Credentials Committee, and ultimately the Governing Board, are responsible for providing oversight of the quality of care and treatment and services provided within the institution by credentialed practitioners. That's during both the initial application, it's on an ongoing basis, whether it's during reappointment or when issues arise, as we'll discuss as we go along here. But also, it's important to note that it is the governing board that has final say in terms of privileging decisions. And I raise that only because it's important the process works all the way through, because we're beginning to see more and more cases brought against hospitals involving negligent credentialing. In other words, a bad event occurs, someone sues the doctor for malpractice, probably names the nurses and everyone else involved, but they're also now naming the hospital saying, look, you knew it was a bad doctor, but you let him or her on the staff, or you were aware while they were on staff, there were issues and you didn't do anything about it. So it's important that the process works all the way through. So, how do corrective actions arise? Usually, they arise from a routine peer review process, perhaps a sentinel event, which is a patient safety event that results in death or permanent harm to a patient. Or you get staff or patient reporting just about any other source, including sources from outside the hospital. For example, malpractice case. When these kind of events are reported, you usually begin an investigative process. We'll talk a little more about that. That investigative process, for purposes of determining whether a further action should be taken. It's very important. It's beyond the scope of this presentation that's done in a way that you protect the information being gathered, whether you do it through a patient safety committee under the Patient Safety Act, or whether you're, ultimately can invoke what we still have as a common law privilege of self-critical analysis. But again, beyond the scope of this, but you want to make sure your process is done appropriately so the information is protected to the extent it can be. And that process ultimately gets to a point where it may result in the recommendation for a restriction, limitation, or a revocation of medical staff membership or clinical privileges. So what are the types of corrective action? This is not an exhaustive list, and it can differ between the healthcare facilities, but generally it's very similar. I just want to let you know that Alex will be getting into which of these events are actually reportable to the National Practitioner Data Bank or to the State Board of Medical Examiners. But here we have summary suspension, which is basically the most severe action that can be taken. That's where there's an immediate and imminent danger to a patient or employee or others. And typically a hearing right will be triggered if it's ratified and continued by the MEC under the bylaws. Most hospitals have a very quick turnaround process whereby the individual affected who's been summarily suspended can actually appear before the MEC to explain why it should be lifted. I've seen everything from 3 to 7 days. I don't think it typically goes any longer than that. And if it is not lifted by the MEC, then of course hearing rights are triggered, takes effect immediately. Other types of corrective action can be what we might refer to as routine corrective actions. For example, FPPE, Focused Professional Practice Evaluations, or OPPE. These are focused basically on provider performance improvement. There's been an issue, and the hospital wants to look a little more closely on the activities of the physician in question. Sometimes it may just end there. But if as a result of that process, there's a further recommendation for action, it may very well trigger the hearing rights. The difference between this and summary suspension is that if the recommendation, even if it's for a suspension, regular suspension, or other corrective action, it doesn't take effect until after the individual exhausts their hearing and appeal rights. That's why you often will see, if it ends up being a pretty severe action, a hospital will go directly to the summary suspension, because hearings take a very long time to come to a conclusion. And then there are automatic suspensions. These are objective triggers set forth in the bylaws. Medical board license suspension or action, criminal indictment, something along those lines. Hearing rights, no. Typically, you don't have a right to appeal that. It's automatic and it's effective immediately. Sometimes it's defined as automatic suspension or administrative suspension. Most common one we always are dealing with is failure to complete medical records. There's no appeal right there. It's effective immediately. How do you get off a suspension? You complete your medical records. But the interesting thing is, for those frequent flyers or the people who are repeat offenders, that actually can lead to a serious quality of care issue. If there's gaps in medical records and other practitioners are providing services to a patient, they may very well raise to the level of quality, and a recommendation may be made to take further action. Okay, what happens? This is the process. It may differ from different hospitals, but it generally follows the same thing. You have a triggering event, an incident report, poor outcomes, sentinel event, RCAs, root cause analysis. That's where a particular problem, bad outcome occurred, and everyone's brought together that was involved in the patient care to figure out what went wrong. Sometimes it ends there as a lesson learned. Sometimes it leads to further action. So there's an initial review, again, to figure out what happened. And it's usually conducted by the appropriate people, the chair of a department, the CMO, whoever, in order to make a recommendation. Now, a request for corrective action can come from, and again, you look at your bylaws, it can come from almost anywhere. Summary suspension may be a little more restricted. Often I'll see that's the president of the hospital, the CMO, the chair of the department, president of the medical staff, or sometimes it has to be two of them. But other requests for corrective action can come from all sorts of different sources. Typically, once that's done, you create the ad hoc committee. MEC sometimes will investigate it as a body of a whole body. I don't see that very often anymore, because MECs tend to be very large, so it's not very practical. But you have an ad hoc committee, or some medical staffs I've worked with actually have standing committees of people they use in order to investigate these actions. And then that committee makes its recommendation to the MEC. Now, if the recommendation, again, is for a suspension or restriction of privileges, you're going to trigger fair hearing rights. That fair hearing, and we'll go into it a little more detail later on, then that panel or hearing officer, if it's just a hearing officer instead of a panel, will actually make a recommendation back to the medical executive committee. It's a medical executive committee that can either approve, reject, or modify the fair hearing recommendation. And then it's the MEC that makes the recommendation to the governing board. Now, if the MEC recommendation is still adverse to the physician, typically they have a appeal action, a right to submit an appeal to the governing board before they make a final decision. It's not a rehearing. The hearing record was established below, and therefore you have to rely upon that hearing record. And then if the governing board, again, comes to a final decision indicating that there is an action that would limit, restrict, or perhaps revoke the privileges, you can go to court. But again, it's a tough case to bring because, one, it's not a rehearing. It's basically you have to show that there were issues with the process. There was some kind of unfair bias or other procedural mistake that affected the outcome. Because the case law is fairly clear. The courts that review these matters defer to the hospital, especially if the hospital followed the process in the bylaws. They're not going to substitute their own judgment. So again, and we basically said the practitioner is entitled to the fair hearing when certain things happen, and it's based upon their conduct. And this can be in two different areas. And one is quality care, which we're focusing on today, but it also can be based on a physician's behavior. And we're going to get into that much more detail in our next webinar. Typical examples, again, what triggers these fair hearings are initial appointments, denial of initial appointments or reappointments, suspension, restriction of privileges, summary suspensions, or a permanent revocation of someone's privileges. So what's the fair hearing? Who are the fair hearing players in the process, and what's that like? First of all, you're obviously going to have the MEC representative and the MEC counsel. They're the prosecutors. They're the ones that are going to bring the case to establish why the action that's been recommended has to occur. Obviously, the affected practitioner has to be there. Most hearing procedures I've seen in the bylaws, the practitioner has to appear, has to be present during the hearing process. And they have the right to be represented by counsel. That was established a long time ago in New Jersey under common law, some cases. So regardless of the Healthcare Quality Improvement Act, they've had a right to be represented by attorneys. As we'll talk about later, that right does not typically, bylaws may say differently, typically does not extend to anything prior to the fair hearing, like a presentation to the Med Exec Committee regarding a summary suspension. You have a hearing panel, and we'll talk a lot more about this later on in terms of the importance of the impartiality and objectivity of a hearing panel. That's probably the toughest thing in this whole process. Sometimes a hearing officer will replace the hearing panel, but typically it's more hearing panel, but there'll be a hearing officer to guide them, not to tell them this is how you have to decide, or I'm telling you the evidence is X. It's to guide them through the process and to control the process of the hearing. There's going to be a court reporter because there has to be a record. Again, remember, if they're going to appeal it at the board level, they're going to appeal it in court later on. It's going to be based on the record established below. Interestingly, very few bylaws I've seen address who pays for the reporter. And quite honestly, even though I come from a hospital and a medical staff perspective, I do think it's quite a burden to place on the individual practitioner. I've seen that in bylaws, and I think that's hard. I think the hospital's in a little better position. A lot of hospital bylaws that will also provide, or medical staff bylaws, that it's split, the cost is split, which is one way of addressing it. And then, of course, you have the board as the appellate review in the end. So what's it look like? It's like a mini trial. Not as strict as would be in a court of law because, for example, you're typically not bound by the rules of evidence as you would be in a trial. And other things are waived. Hearsay documents are allowed in that maybe would have been, fought over in a court. Try to actually create as complete a record as possible. So that's kind of the lead up to corrective action, fair hearing process. I'm going to turn it over to Alex now, who's going to walk you through the National Practitioner Data Bank and other reporting rules. Alex?
All right. Thank you, Todd. Good presentation and right on time as well. We'll go in advance to the next slide. Give me a moment here. There it is. The National Practitioner Data Bank. It's really hard to exaggerate the effect that the National Practitioner Data Bank had on the dynamic of healthcare. And over the last 50 years, there's been a lot of dynamic issues in healthcare. Obviously, the advent of managed care and how it is pretty monolithically taken over the healthcare system happened, probably started long before the data bank came around in the 1980s and 90s. But with the National Practitioner Data Bank, the dynamic changed for reporting, for adverse actions, for credentialing in a very profound way. And the way that happened was, and to give you a little history lesson, and many of you already know, before the 1980s, if a physician was disciplined by a medical board, if he was sanctioned by a hospital through peer review action, if he was thrown out of a surgical center or some other practice for whatever issue arose, he could simply go to another practice, another hospital, another state, and sometimes what often happened, and I heard about it quite a bit when I was with the Attorney General, I would go to a federal healthcare facility like a federal prison or the VA and just simply practice over there because there was no effective way for an adverse action to be reported nationally whenever a physician or any healthcare provider or any healthcare supplier became the subject of an adverse action through peer review. So in 1986, Congress passed, and it was enacted in 1989 as part of the Federal Healthcare Quality Improvement Act. And that did two things. It created this clearinghouse, this National Practitioner Data Bank, where all adverse actions against healthcare providers from any source, hospital peer review, third-party payer actions, medical malpractice actions, criminal law enforcement actions, licensing actions, regulatory actions, anywhere. The National Practitioner Data Bank is generally the bottom of the funnel where all of these adverse actions are reported so that healthcare entities across North America can simply, in a credentialing or an onboarding issue, reach down, go into the data bank, and find out if that healthcare provider has any prior adverse actions. And that's the general reporting system. The other very important part of the data bank was immunity. When the Healthcare Quality Improvement Act was passed, two things happened. It created this national clearinghouse, National Practitioner Data Bank, and it provided immunity for any individuals, physicians, and other administrative persons involved in the peer review process at the hospital level. This is very important because, number one, it incentivized doctors to commit to peer review and therefore risk management and compliance. But there's also an underside to that. Many people would feel that it also incentivized doctors to have a mechanism, a legitimate immunized mechanism to go after fellow practitioners and colleagues and target them for various reasons because of this immunity. And that's really the big issue, and that's a giant issue with regard to peer review at hospitals. And Todd and I are going to discuss that in much more detail and during our panel. The way the data bank came about is actually very interesting. Ron Wyden, who was a congressman in Oregon, who is now the senior senator in Oregon, was privy to a lawsuit, became aware of a lawsuit brought by an Oregon surgeon in Astoria, Oregon, who sued a peer review panel who had made him the subject of an adverse action with an antitrust suit. And there were two things happening at the same time. There were a lot of these lawsuits happening. Physicians targeting these peer review committees that have brought them under scrutiny, but also an increase in medical malpractice actions in general. This was a time in the 80s when litigation in general was exploding. People became much more prone to bring lawsuits, and especially medical malpractice suits. So Congress acted by bringing in the National Practitioner Data Bank and providing immunity for peer review members that get involved. It's important, if you want immunity, you have to make sure that a peer review activity actually took place. Peer review, professional review activity, or peer review activity would be an activity that's brought into place to determine whether a physician has clinical privileges with respect to or membership in the entity. And it could be any entity. It could be the hospital. It could be a professional society. It could be a specialty board. But any type of privileging actions, that's where this type of immunity would kick in. A peer review, professional review action to determine whether somebody gets privileges, the scope of privileges or membership, or to change or modify any type of privileges or membership. And the standard, in order to get the immunity, the standard must be met. Reasonable belief the action was in furtherance of quality healthcare. In other words, legitimate, not mercenary reason for bringing this adverse action against this healthcare provider. A reasonable effort to obtain the facts, and that is this kind of the activity that Todd just described. Generally, this peer review or this sort of due process, and I know Todd feels the same way. I'm sort of hesitant to call it due process because when we think of due process, we think of the more formal structure in a civil or criminal matter. It's not quite the same, but it is the ability, for example, at a hearing, to bring witnesses, bring exhibits, and defend it for the doctor or the dentist or healthcare provider to defend themselves. A reasonable effort to obtain the facts and a reasonable belief that the action was warranted by the facts known after reasonable effort. More specifically, a thorough investigation in which the medical staff feels there is a reason to move forward. There's a reason to take remedial action against this particular provider. And reporting corrective action, this is where it gets a bit complicated, and this is why it's really important. when physicians get involved in any type of, they come under scrutiny by the medical staff at a hospital, or for that matter, a medical board, third-party payers, regulatory agencies, anyone, is to understand whether the adverse action or the investigation is going to be reported and to whom. As an example here, you see reporting to the National Practitioner Data Bank, reporting to state medical boards. There are state reporting laws that require under state statute that if a doctor is the victim, I'm sorry, I say victim, I'm advocating for the doctor here. Todd would say the subject of an adverse action by the hospital medical staff. If it's a summary suspension, a precautionary suspension based on a serious quality of care or misconduct issue, that must be reported to the state medical board in New Jersey by law, but it would not be reported to the data bank unless that suspension period goes beyond 30 days. And many practitioners get confused about this because they'll say, oh, had a summary suspension, but it hasn't gone past 30 days, so it doesn't get reported to the data bank. Well, no, maybe not, but it gets reported to the medical board. And here's where it gets a bit complicated, because if that matter gets reported to the medical board, separate investigation by a separate entity, and that comes to fruition as an adverse action by the medical board, that can get reported to the data bank, even if the subject matter in the hospital does not go beyond the 30-day period. So again, it gets very complicated, and keeping abreast of this and understanding succinctly where these matters get reported, by whom, and how is really, really important. The National Practitioner Data Bank has a guidebook, and I have to say it's pretty amazing because anybody who's been involved in looking through government websites, you often find they're not very user-friendly, to say the least. The National Practitioner Data Bank is actually a very user-friendly site. Anyone who goes onto it, the format and the way it's structured is very easy to navigate. A lot of it is question and answer portions that really help not just practitioners, but lawyers have a better understanding of what gets reported and why. So that's definitely worth looking at whenever either your client or yourself are under any type of scrutiny and the data bank gets invoked in any way. Now, the important thing, of course, who may access the information on the data bank. There's some confusion here as well, because if there's an adverse action or final adverse action by the Board of Medical Examiners, say, for example, or in New York, the Office of Professional Medical Conduct, it'll almost inexorably be in the form of an order. When it's in the form of the order and entered, the state licensing board, and this is across the country and in Canada as well, in the provinces before what they call the medical colleges there, that order will be entered. And if you go on any of those licensing board state websites and look for a link called disciplinary actions, you will see the record of discipline against these doctors. The data bank, that's public information. Any public member in New Jersey, any citizen can go on to the website and find that. The data bank, citizens, common people cannot go onto the data bank and look for adverse actions against doctors, but the most important people can, and that are folks who are credentialing these physicians. A physician applying for privileges in a hospital, a physician applying for licensure, applying for third-party payer status with a commercial or government payer like CMS or Medicaid at the state level, a physician trying to enter membership in a medical society, trying to become board certified. Someone's going to check the data bank before this type of credentialing takes place. So all of these institutions, every one of them, all have access to the data bank and reporting, which means that for credentialing, any entity that has a need to know whether that physician or that dentist or a provider or supplier has had an adverse action against him, they will have access to the data bank, and the physician themselves will also have access to the data bank in what's called a self-query. And that's it's often difficult for counsel because we have to explain to doctors, I want to go on the data bank, I want to file a response to a data bank report, I want to check in the data bank. They have to do that themselves, only they have access. They have to use their own code to get in and to do these things. So what must be reported? It's really important to know the adverse actions that are reported. Certain medical malpractice payments, I say certain because as somebody who's handled medical malpractice defense, what you want to do, if possible, to avoid a report to the data bank from a medical malpractice settlement or judgment is to try to take the causes of action that are not related to quality of care or other issues and try to settle it under those causes of action so that it does not get reported to the data bank. That's probably a subject for another slide, but there are certain causes of actions within medical malpractice that may not be reported to the data bank if that's the final finding, and that's why it says certain. Licensure certification actions of any type, if it follows a professional review action, that's reported. Adverse actions taken by healthcare entities related to, and the two things that will be reported to the data bank are any professional review actions with a resultant finality that are the subject of professional misconduct or competence. However, as Todd said before, very important, and it's going to be a very interesting subject of our next presentation. Disruptive physicians and matters related to civility and communication, they also can become and come under the rubric of professional conduct or competence because they are considered today to be related to patient care. Now, it's frustrating for physicians because they basically will say, well, people don't get along with me, or I get in these fights all the time with nurses. I got reported and I became the subject of a peer review action, and it has nothing to do with quality of care, impairment, or misconduct. Well, according to the hospital, it does. So that's something that we're going to cover in our next presentation. Healthcare-related convictions and judgments. To be clear, not only administrative matters at hospital level, licensing board regulatory matters, or third-party payer matters that come to finality are reported to the data bank. Also, judgments, civil judgments that might relate, for example, to fraud or misconduct, some brought by third-party payers, for example. A lot of actions brought by the New Jersey Medicaid Fraud Division or the Medicaid Fraud Division in New York also are reportable to the data bank. And of course, exclusions from participating in federal or state health programs. Can be called exclusion or preclusion, but it's when Medicare or another federal entity knocks out your participation in their program, which is often devastating to a physician. That gets reported to the data bank as well as on the exclusion list for CMS. It is important for physicians to know if they do lose or they have suspension of their medical license, they do not automatically get back all the other credentials they need in order to practice, their CDS registration, their hospital privileges that they had previously, their status with CMS or other commercial payers, their specialty board certification, et cetera, et cetera. So the dominoes fall as the person is suspended or becomes the subject of an adverse action, but they do not fall back automatically when the person gets his license restored. And that's really important to remember. So with that and other healthcare-related adjudication actions and decisions, and again, to be reported to the data bank, it has to be related in some way to healthcare. Reporting adverse clinical privileging actions. Again, it has to be a professional review action, starting with an investigation and going through the entire template that's needed in order to say, and the doctor will have notice, are undergoing a professional review. Here are the steps. It has to be based upon professional competence or conduct and adversely affecting a physician's or a dentist's clinical privileges, and it has to be for a period of more than 30 days, as Todd said. The trigger for the data bank reporting is when that restriction, that suspension, that condition lasts more than 30 days at the hospital level. Examples of actions that may be reportable, and Todd had covered some of this: the denial of a request for clinical privileges, a summary suspension if it lasts more than 30 days. Again, I mentioned before, and again, herein lies the confusion. A summary suspension itself will not be reported to the data bank upon that summary suspension being invoked by the hospital. However, if that summary suspension goes past 30 days, that's the trigger for reporting to the data bank as well. And it's something to keep, when these matters happen, and Todd and I know when you have these adverse actions, keeping a calendar is really, really important in that regard. Limitation of clinical privileges may be reportable, depends on what it is. I'll give you an example of what can be considered a limitation of clinical privileges of sorts that's not reportable. Oftentimes today, and many folks on medical staff of hospitals that are teaching hospitals will see this happen a lot. A doctor will have some problematic relationships with the residents who are being taught, and the residents will get together and say, we can't stand working under this doctor anymore, he's terrible. And that doctor may be excluded from participating in teaching those residents and having the support of those residents. Now, technically, you can say that that is a restriction or denial of some type of privileges because that doctor has lost that ability to get that surgical assistance from those residents that he had before. But nonetheless, that is not considered a condition or restriction of medical staff privileges, and it's not reportable to the data bank. So that's one example where it gets tricky and somewhat complicated. The implementation of proctoring requirements. If the proctor for the doctor is someone who has some type of input or fiat or carte blanche over what the doctor may do or not do and restrict him or condition him in any way, that would be considered a condition or restriction of privileges, as opposed to a proctor who's simply reviewing and looking over and monitoring that physician. A voluntary surrender or resignation of privileges while under investigation or to avoid investigation. That's verbiage from the data bank itself. And here's the tough part in the first bullet point: even if a practitioner is not aware of the investigation. As amazing as this may seem, there are instances where an investigation has ensued at the medical staff level and a physician is not even aware of it yet and may suspect it or may feel tension in the air and resign his privileges while that investigation is ongoing, in spite of the fact that he or she is not aware. I have had cases where a doctor has left what he considers to be a poisonous atmosphere at a local New Jersey hospital, gone and done locums over in Texas, and finds out that he's been reported to the data bank for resigning under investigation he did not even know about. And that's one of the more draconian aspects of the data bank and how it works. An investigation is what the National Practitioner Bank says it is, not how it's defined by the eligible entity. Resignation of privileges while under a focused professional review action, and some leaves of absence, if during the leaves of absence the physician's privileges are not able to be used at that level, at the clinical level. Actions not reportable: if you withdraw an application for appointment to the medical staff prior to the professional review action starting, and then that's the whole key, is getting outside of the scope of that professional review action, so there's no reporting. And a denial or restriction of privileges when based on a failure to meet threshold requirements. For example, some hospitals want you to maintain board certification in order to do surgery. If you lose that board certification, you will not be able to keep your privileges, but you won't be reported to the data bank. Routine FPPEs, administrative action resulting in suspension of privileges, something that's more HR related rather than medical staff related. And a termination of an employment contract when it's based on termination procedures rather than professional review. And I'll give you an example of that. A separate employment contract that the physician has with his practice group that may be affiliated with the hospital that requires him to maintain board certification. The physician loses board certification, and under the terms of his contract, can no longer keep privileges at the hospital because the contract says so. That also would not be reported. And of course, suspensions and privileges not exceeding 30 days. It's interesting. There's some issues, of course, where you have three different things going on with a physician when an adverse action occurs. Rutgers University, for example, in New Jersey, is a teaching hospital affiliated with a hospital system, RWJ Barnabas. A physician at that level could, for example, have an issue with his medical staff privileges, which is a subject of an adverse action at the hospital level, an issue with the employment contract with whatever practice group he's with, may be affiliated with the hospital system, and a tenure issue with regard to his teaching position as a professor at Rutgers. And this isn't just Rutgers, it's all over the country. So you have three different issues that might be dealt with, three different levels of peer review or adverse actions, and three different types of legal issues that might require the kind of acumen you need from different lawyers as well. And that's something to keep an eye on as well. And state law reporting, again, it's different in different laws. And I want to say again in closing, it's really important to understand the different state licensure board requirements for reporting. For example, in New Jersey, if you are a physician and you are arrested for any reason, domestic violence, DWI, whatever it might be, a bar fight, not related to healthcare, but nonetheless you are arrested, that must be reported within 10 days to the State Medical Board of New Jersey under state law. In New York, if you're also licensed in New York, that same physician, you need not report that arrest, but you must report the conviction. If you end up with discipline by the State Medical Board of New Jersey, if you have a license in Florida that is inactive, that you haven't used in 20 years, you haven't practiced there in 20 years, you still need to report another state's sister state licensing board action to Florida, or you can be sanctioned there as well. So that closes my type of the presentation, and Todd and I will now move on to the panel discussions. And sort of wrap up what we discussed here. And Todd, I'll let you start.
Sure. Thanks, Alex. And that was an excellent overview of the National Practitioner Data Bank and all of the somewhat confusing reporting requirements that everybody grapples with. We had a couple of issues we'd like to cover in the panel discussion. I'll start off here with the first issue is, do bylaws of a hospital really provide sufficient due process for professional review action? And is the process fair and neutral? I'm pretty sure I know where Alex comes out on this with regard to the individual physician. So I'll kind of give a hospital medical staff perspective, and then he can tell me why I'm wrong. But basically, there are problems with this process. But the point is, we're stuck with the process that we have, the construct, because of the Healthcare Quality Improvement Act, because of state statutes and case law, because no one wants to deviate in terms of the process, because you don't want to lose that immunity. So we're kind of stuck with the process. Having said that, probably the biggest problem and key issue and biggest challenge is maintaining impartiality throughout the process. And that's a tall order, beginning with the hearing panel. If you have a hearing panel, the hearing panel has to be neutral and objective. You cannot have people on the hearing panel that are in competition with the practitioner. You cannot have people on the hearing panel that already were involved in the decision below. You got to find people who know nothing about the doctor. Best panel I've worked with is one that didn't even know who the doctor was, and they didn't have any information going in. It's difficult to do because it's hard to find volunteers, quite frankly, because these hearings are very lengthy. They take up a lot of time, and it's quite an endeavor to volunteer to be on one of these panels. But you need to have that panel right from the beginning. The bigger challenge, if you do that right, your bigger challenge then is the Medical Executive Committee. Hospitals are political, and it is very difficult when the recommendation gets up to the MAC that you've controlled the MAC. They've been talking about it, perhaps. They have their own biases. They may have information. You really got to make sure anybody on the MEC who is either in competition with that individual or who was involved before in any part of the investigation process recuses themselves from taking part in the decision. You got to keep it objective, impartial. And then, of course, at the board level, too. Probably less of a problem. A lot of times the boards don't know, but no one should be reporting up to the board during the process, talking about what's going on. The board shouldn't even be discussing it until it actually reaches them for action, because quite frankly, it may end below. So, keeping this impartiality is incredibly important. If you're involved in the process and you're advising someone, the thing I like to say is, panel, MEC, and board, if anyone approaches you to talk about the case, and when I say anyone, I include the affected practitioner, you need to report that to either the head of the hearing panel or the medical staff leadership or to the chairman of the board, because you shouldn't be discussing it outside of the process. And that's really the tough part about this. Alex?
Yeah, Todd, I don't disagree with anything you've said. I think the big issue here, and it's been the big elephant in the room with regard to hospital adverse actions. I don't know exactly how to term it, but it has to do with what was before years ago and what is now. And more specifically, in the 1980s, no way how to put it, but there was effectively an organizational administrative wall between the medical staff and the hospital administration, which was very important because you had the medical staff dealing with the clinical issues at the hospital, or the providership of the hospital, and the business end, the hospital administration, totally separate. And the peer review process was this time-honored method of self-policing within the medical staff, within these doctors, unaffiliated with the administration of the hospital. Fast forward to the drastic changes in the healthcare system since the Healthcare Quality Improvement Act and the data bank. Now it's 2024. Healthcare has been increasingly consolidated into these monolithic hospital systems to which the physicians are now affiliated, breaking up that sort of separation, that wall between the hospital administration and leadership and ownership and the physicians themselves, who were formerly just coming to the hospital because they were members of the medical staff, but had no other affiliation with that hospital. That's the only way I could put it. And I think you spoke to it well. It makes it a bit difficult to really discern who may have a conflict and who may not. And I reveal you and I were on adverse sides when you were hospital counsel and I was doing what I'm doing now, but you were fair enough and to ensure that whoever was involved in the peer review process was someone that would not have a conflict. And it certainly behooves any attorney representing a physician in a peer review action to make absolutely sure that everything is fair from the hearing officer to the actual members. Which takes us to our next panel discussion, number 2, and that is, shouldn't all disciplinary actions at hospitals follow the same progressive discipline pathway like the Vanderbilt model? Let me first explain the Vanderbilt model for folks that don't know. The Vanderbilt model is a model of progressive discipline that's used by a lot of hospital systems here in New Jersey and across the United States. It's a model system which starts with first, in order to give the medical staff member a fair chance to sort of improve before real remedial or punitive measures are put in place, to first sit down, consult with the doctor, explain what the issue is, what's called a coffee talk, and then progressively, if it doesn't improve, to impose more and more sanctions against that medical staff member or healthcare provider. And by the way, this is also done at the human resources level with nurses and other providers who are not medical staff members. So the fact is, and the reason I think this is a subject of a panel, is that hospitals seem to be all over the place, at least in my opinion, where a doctor in one hospital becomes a subject of a summary suspension because of what are basically communication and civility issues. And 10 miles away, another doctor who's done the exact same thing gets the coffee talk. And there just doesn't seem to be any commonality or any type of template that's fair across the board. And I think that's one of the problems. But obviously, I welcome your thoughts on that, Todd.
Yeah, no, I agree. Most issues can be resolved through a peer-to-peer process, and it's a better approach. Corrective actions that end up with fair hearings are costly, to both the hospital and the practitioner. And if you can resolve it peer-to-peer, I agree. It's interesting. The vast majority of actions I've ever been involved in, whether I was representing an individual physician or the hospital medical staff, they never get to the hearing because people are reasonable and they work it out, and it becomes an issue. It may result in a temporary suspension of some period. It may result in, a more focused review, but the peer-to-peer resolution is so much better than getting all the way to the nuclear option of, limiting, revoking privileges and everything that flows from that.
No, I would agree. And that's where the FPPE, if used effectively, is obviously a good tool, which takes us to our next panel discussion, number 3. And that is mine. Shouldn't a physician be able to sue a hospital and its leadership when they are being unfairly targeted? More specifically, many have claimed and many will claim that the Healthcare Quality Improvement Act, in invoking this broad immunity for any healthcare entity and hospital medical staff that brings an adverse action, it sort of incentivizes these individuals who may have a personal gripe or political or economic vendetta against this physician to target him through the peer review process. And the term often used is peer review execution. There has been lawsuits, there's still lawsuits against many hospitals by physicians against their peer review enemy, but they're very difficult to bring, and immunities often come into play, not only through the Healthcare Quality Improvement Act and the immunity that provides, but also through some of the SLAPP statutes and the model SLAPP acts that have been brought and been invoked in different states, including New Jersey, that will knock out things like defamation claims. Now, I certainly agree that peer review bodies should not fear lawsuits. We have immunity for prosecutors in criminal matters for a good reason. We know that if people were just allowed to sue prosecutors and bring the process to the end, the courts would be filled with lawsuits against prosecutors every time a criminal defendant was a subject of an indictment. But at the hospital level, there's a dynamic and a political element that can't be denied. And I think part of that is the fact that there are doctors who will target other physicians, and bringing back that rubric I described before of more hospital-owned systems where doctors practices are now owned by hospitals. Oftentimes, a physician who is on a medical staff who decides to keep their own practice and not come under the umbrella of the hospital, or a physician who takes most of the call, or a physician that doesn't get along with his fellow colleagues and others for whatever reason, they can become the target. And there's just too much incentive to use peer review as that mechanism because of the immunity. That's my take on it.
Yeah, no, I don't disagree. When the process is clearly corrupted, there should be a recourse for the affected practitioner. That's why it's so important to do the process correctly and have the right people, the right leadership, the right people on the hearing panel, et cetera. So you get a fair, objective hearing. But it is a problem because people hide, as you said, behind the immunity. We followed the process exactly. So, we're immune. My argument and concern about bringing these types of lawsuits, certainly they shouldn't be brought during the course of a fair hearing. It should really be after the fact, but it's going to have a chilling, and you kind of mentioned that it can have a chilling effect on physicians wanting to be in leadership roles, physicians wanting to participate on a hearing panel, administrators wanting to take a tough stance. As much as we tell everyone, don't worry about it, you've got insurance. We've got directors and officers liability insurance. You're going to be protected. It's considered an administrative act. Nobody wants to be sued. It's, you may not have liability monetarily, but you've got a time and disruption and all the horrible things that go on, unfortunately, when somebody's sued. So it's a tough situation. We shouldn't be hiding behind immunity if we're not really following and being fair in the process.
Don't disagree with that. And that's on to panel discussion number 4.
Sure. This is where we get into the issue that we're going to go into a lot more in depth in our next webinar. But why can't civility and communication issues at hospitals be handled by human resources? And how does the manner in which a doctor speaks, acts, or communicates relate to patient care? Again, we'll go into more depth at the next. I think the only point I want to make is we've had long, certainly in New Jersey and in other states, long established law that actually disruptive behavior can affect quality of care, and you don't have to wait for the adverse event, or as we say, you don't have to wait for the dead body. If you have a disruptive physician, it can affect quality care. You could take action against them. The problem is when you have the situation where you got to balance a physician's due process rights with the fact that the HR department's received a complaint about that physician, and they have a duty legally to give a prompt remedial response to deal with the issue. If it's an employed physician, it can usually be handled through the contract. But if it's a volunteer physician, you now could have 2 investigations going on simultaneously, and you can essentially end up with 2 different results. But again, we'll go into that more in the next one. Alex, I don't know if you wanted to add.
That's a very good point, actually, and that goes back to my Rutgers example of not just possibly an HR issue, but a tenure issue and a medical staff issue. So certainly, I guess we can move on to the next panel discussion, which is yes, shouldn't the doctor be permitted to have counsel present and involved at the MEC hearing? That has always been problematic for me because technically, when you talk about an adverse action, when you talk about a professional review action, when you talk about investigation, every single stage counts. And at every single stage, there should therefore be counsel present. Medical Board, New Jersey. I was a prosecutor. I handled many cases in the last 25 years since. Every time there's a preliminary evaluation committee hearing at the medical board, the physician's allowed to have counsel present. He's allowed to have counsel help him provide a response to a patient complaint. The hospital is different in that the MEC, which can make a very pivotal decision about that physician, doesn't allow counsel present, or if they do, and it's happened recently with me, they allow counsel to be present, but mum's the word. You're only allowed to observe, not speak. So obviously, I welcome your thoughts about that.
Yeah, no, and I understand the concern there. I know few, if any, hospitals that allow the counsel to be there, when it's at the stage of just before the MEC, like after a summary suspension. Part of the problem is once attorneys are involved, the whole vibe becomes a little more adversarial, and it gets a little more difficult. I like to think at the MEC, hopefully, if the MEC is good, we're still at a peer-to-peer step in the process, and they may be able to resolve it. I understand your concerns. I just worry about the chilling effect of all of a sudden attorneys now presenting at the MAC level. I'm not sure that will help it. I'm not sure that that will change the things and may actually make it a little more difficult. But we'll agree to disagree on that one.
Fair enough. And the last panel discussion, that's yours.
Yeah, should a doctor remain on the medical staff of a hospital when they've been subject to a professional review action? This is a real catch-22 for physicians. And Alex, I think you have a good point you'll make on with regard to figuring out whether you got a fair shake at that hospital. But in our case, or from my perspective, this follows you wherever you go. So it may limit your options because everywhere you go, you're going to have to disclose on an application that you were subject to a review. And if it was reportable, obviously they're going to have it. So it's challenging. You may have limited options to leave and find another place to work.
No, that's fair enough. And just being involved in employment law, I always think in general, if you are in a toxic workplace environment, the best thing to do is exit. So, but fair point. And I guess that takes us to questions. Phoebe, do you want to pipe in here?
I think, Alex, we may be short. We have just a few minutes left. Perhaps we should, unless you want to jump into one, I think we may say we'll follow up with people. We have obviously who the questions are from, and we can send those answers out. Because I think we're at the point where we ran out of time, unfortunately.
Sure. Yeah, we can do that. We can take the questions we have, and I see a lot of raised hands. We'll take all those questions and answer them remotely after this presentation. And I think it's 11:57. That gives us 3 minutes. We did start a little late to get everybody on board. Any closing remarks?
Not from me. Do you want to wrap up?
No, I think it was a good presentation. I'm glad that we did it together because, again, I think you have a unique perspective and frame of reference, having been at the hospital level as in-house counsel. I know that, having been on the other side, there's a different perspective and vantage point for me as well. I worry always, and I warn doctors about the political element and whether or not the peer review action against them is a fair one on several levels, whether the quality of care involved was actually at a level that really warrants the type of disciplinary or punitive level that the hospital's seeking, but more than that, whether it's brought as a type of peer review execution. So next discussion we'll have in the next webinar is going to be very interesting, which is the civility and communication issues and how that has become the sort of flavor of the month, the year, the decade lately. So we'll wrap it up with that.
We'd like to thank everyone for joining us for this webinar, for the first part of the webinar series. We hope you found the discussion helpful and insightful. This is just the first in a three-part series. Part 2 will be on June 25th. And again, as Alex just mentioned, we're going to focus on the civility and communication issues related to disruptive physicians. If you have any further questions or need additional information, don't hesitate to reach out to us. Again, you have our contact information, and we will follow up with the individual questions. We got quite a few. So I'm sorry we didn't have enough time to get to it, but we will work on that. Thank you once again for your participation, and everyone have a great day. Thank you.
Thank you, everyone. Have a good day.